Welcome back to the Morning Show here on Arise News.
Switching the topic now, the people of Imo State are refusing to accept the verdict of the Supreme Court over the removal of Emeka Ihedioha. Imolites protesters have shut down Owerri, the state capital.
Well, the protesters took to the streets over the weekend over the removal of Mr. Ihedioha by the Supreme Court and the declaration of Hope Uzodinma of the All Progressives Congress as the duly elected governor of the state.
Well, PDP members also joined in the protest that took place around the state capital, calling on the jurists to revisit Tuesday's verdict, which sacked Ihedioha, and insisting that the protest will continue if the court refuses to revisit the Imo governorship debacle. Well, joining us now to x-ray the legal implications vis-a-vis the court's judgment is Tope Akinyode, a legal practitioner and public affairs analyst. Now, welcome back to the show, Tope. Happy New Year.
Yeah, I wish you the same. It's a great job being here once again.
Yes, this is a very, interesting case. We get this landmark judgment from the Apex Court saying that, Emeka Ihedioha should be replaced by Senator Hope Uzodinma, who's now the governor, of course. Now, this protest, they're demanding a reversal on the judgment. Now, we know that the ruling of the Supreme Court is sacred and final. However, they still went ahead with this protest. Can it be overruled? Is there any precedent for this?
All right, okay. Now, to start with, when I was here to discuss the election tribunal of Atiku Abubakar, I did make a strong case for an overhaul of the existing electoral architectures in Nigeria. And my reasons were clear that if we have to go this route, we create a great problem for our democracy. And part of those things which I have said are the things unfolding now. The Supreme Court, as you have said, is sacred and final in its judgment. And because of that nature, there's a tendency that sensitive issues that has to do with electoral matters shouldn't be a free-for-all to be dumped on the Supreme Court. Going to your answer to your question, under the law, it is very, 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 very strict provision that the Supreme Court cannot revisit its case. But there are some exceptional circumstances, and there were 2 or 3 of them. And the court held so as far back as 1971, the Supreme Court, in the case of Johnson against Lawanson, the Supreme Court held that if there are clerical errors or reasons to give effect to the judgment of the court, or there is fraud, these are bases upon which the court may reconverge to look into its judgment. Now, coming to the issues about Imo State.
Sorry to cut you. Was there a precedent in the case of Johnson and Lamas in 71?
Yes, there was. The court actually
so the Supreme Court
yes.
actually what was the premise at which the Supreme Court revised?
Well,
because we're setting precedents, and I want you to also quote the second case so we can see both precedents.
Well, there's another case that is linked to it is in 2007, but the Supreme Court did even overrule it, and that's in Andrew Bass case. But in 1971, the Supreme Court actually sat, reconvened over a judgment it had held, and said because there is fraud in that judgment, because one of the parties concealed facts from the court which misled the court to reach its judgment. In law, we call it the court reaching its judgment par incuriam. If the court reaches its judgment par incuriam, it can reconvene to reconsider that judgment. But I'm not certain that that is entirely the case in Imo State.
Because that provision is quite different.
Let's look at the facts of the case, because you're a lawyer and you deal a lot with facts. He who asserts must prove, isn't
definitely.
it? In this case, Governor Hope Uzodinma simply proved that these votes were unlawfully excluded. His votes, isn't it as simple as that? He was able to prove, he asserted, And he was able to prove it, and he's governor. Shouldn't it be that simple?
Oh, well, if you ask me as a lawyer, I will tell you it is not that simple.
Okay.
And this is because in the Nigerian jurisprudence, we deal with what we call precedents. The precedents about electoral matters before this case was laid in Atiku Abubakar's case. And in that case, the Supreme Court held that to prove non-compliance with electoral practice, each and every polling unit in which the malpractice or the non-compliance is alleged, evidence must be adduced by calling witnesses from each of the polling units. In that case, we had thousands of polling units. The court held that Atiku Abubakar was unable to prove its case on that ground. In this instance, Hope Uzodinma is saying 338 polling units.
88.
388, sorry, polling units had the result excluded from collation by ANEC. And that the results of those 388 polling units are substantial enough to grant him electoral victory. In court, he called 54 witnesses.
54 people.
Out of the 54, 28 witnesses came from different polling units. So that precedence didn't take effect in this case. So it is a strange, if you would say, judgment to legal minds like us. But I must add that the Supreme Court, as I've said, has the power to revisit itself. And in another case, it can revisit itself through another case, which I guess it is what it did in Hope Uzodinma's case.
But if the electoral umpire in the country, INEC, disowns this election, which they did, they disowned the election saying the results that you had,
yes,
this is not our results.
Yes.
Why do you think that the Supreme Court went ahead to accept these results?
Well, because we have not had the full judgment of the court or the reasoning of the court.
That brings
we
me
are
to my
left
next.
to guess largely about the reasons.
That brings me to my next question. Like you just said, the records of proceedings have not been made public, so we don't know the reason adduced, right?
We don't, yes.
However, we are getting this pushback from the PDP saying that the numbers don't add up, so they have their proof. Now, looking at it holistically, because of, I mean, you've spoken about rehauling the entire, election tribunal system. Now, is it not something that when they are releasing this judgment, the reasons should be released as well? Because it leaves room for guessing, it leaves room for people trying to understand, and protests like this begin to happen in different parts of the country.
Okay. I may not want to go into the reasons why people accept or decline or refuse to embrace or accept, in quote, in good faith, the reason and the judgment of the court. Whether it is out of mischief, whether it is political, I may not want to go into those details. But the Constitution and the Electoral Act actually vest the power on the court, at any court at that, to give its judgment and then reserve its reasons. But I've argued here before, and I'm making that same position, which is more like an appeal to the Supreme Court, that because of the sensitivity of election matters, and especially because of this particular one, that has to upturn the political climate in Imo State, it will be too sensitive for us to have to guess and, and rattle our brains
It makes sense of the judgment.
on the reasons for the judgment.
Okay, I want to come in here. I want to correct technicalities now. I'm not a lawyer, but correct me if I'm wrong. Let's say election petition is sui generis, in a class of its own.
Yes.
You cited the antecedents of Atiku Abubakar. Correct me if I'm wrong. Had the Supreme Court said, the precedence that was set for Atiku Abubakar is not necessarily the one that was set for Hope Uzodinma.
Yes, the Supreme Court can do that.
Can do that, right?
Yes.
Yeah, because when you look at the antecedents of both cases, it's quite different. And the major evidence here was that of P54, that police officer.
Yes.
So it goes back to even the veracity of the evidence. So it's the word of the police against that of INEC. How do you juxtapose the gulf between the police, the Constitution is supposed to be at the polling units to provide security, and the electoral umpires?
All right, well, at the tribunal and then at the Court of Appeal, the court said, no, the police cannot be a valid witness to this case, and expunged P54, that's the police officer.
Yeah.
We got to the Supreme Court, and the Supreme Court said, well, we are going to allow his evidence and rely upon it and grant, the relief sought, by the petitioner. Like I've said, the fact...
But what's the veracity of a police officer to have results and that evidence and it will be taken? And let me take you back down to the Atiku Abubakar case. Let's not forget, we have the same data analyst that came to interpret data, but the court was quick to say that data analyst had no veracity, even despite the fact that he came from Kenya.
There are two different cases in that. And I'm not trying to speak into the mind of the Supreme Court. Apparently, we have to do so much of guesswork. But from the facts of each case, each of the cases, I'm going to draw, delineate a boundary.
Yeah.
For the P54, the police officer is an officer of the state, recognized by the state to mount and monitor election activities.
Does the state recognize his input on results?
Apparently, the Supreme Court did.
Okay.
The reasons why we may not be able to say yet, which is where I don't want to speak too much into the minds of the court. Like I've appealed already, it is important that legal analysts, have the facts and reasoning so that we can match the two, and then, for judicial review for holistic discussions.
Mr. Akinyode, I kind of agree with you more. You're very correct. We'll go on a break, but when we come back, we'll talk about the role of the umpire itself, INEC, in all of this debacle. The legal implications, or the illegality of what has happened so far. You're watching The Morning Show here on Arise News. We'll go for that break now. Please stay with us. Welcome back to The Morning Show here on Arise News. We're looking at the fallout from the Imo State March 9 governorship elections. Actually, that election went all the way to the Supreme Court, and Hope Uzodinma was eventually declared the validly elected governor just some days ago. Tope Akinyode, legal practitioner and public affairs analyst, is here with us to X-ray actually what has happened. Thank you so much for staying with us. I like to bring in INEC proper here, because when you look at the preconditions for the cancellation of results or elections by INEC, they include violence and overvoting and so on and so forth. When you look at that on one hand, and on the other hand, the number of affected polling units that Governor Uzodinma prayed was 388. And when you look at the numbers, the outcomes of voters from that polling unit, over 200,000. So there were enough to upturn the outcomes of the election, which he eventually did. When you look at all of that together and look at the role of INEC, should INEC not have declared ab initio this election inconclusive?
Well, for whatever it's worth, the decision of the Supreme Court, the General of the Supreme Court, passes as a result, an examination result for the INEC chair and the entire commission as a whole, and it's a field mark.
Sorry to come in here. Also owing to the antecedents that Ihedioha did not get the constitutional stipulated 2/3 spread
required.
Let's not forget that angle too.
Well, I'm aware that all the parties, all the petitioners, the three of them, because there are 3 petitioners against Ihedioha's case, were praying the court that Ihedioha didn't have a 2/3.
Yeah.
I'm not certain that the court agreed with them on that ground. But for whatever it's worth...
The same court that held the ground during the case of Awolowo and Shagari in 79?
Well, two-thirds is a fundamental constitutional requirement. But I'm saying that I am not certain that the court agreed with them that Ihedioha didn't pass the two-thirds test. That's my point. But I'm saying generally that as far as INEC is concerned, it has performed quite woefully in its responsibilities that is vested on it.
Do you think the INEC is constrained? Because we do know that the electoral umpire cannot cancel concluded elections.
I do not think INEC is constrained. I believe strongly that they have failed, and I don't know the reasons. Because I have analyzed this before on Article's case to say there's a floodgate of litigation that is let open upon the court arising from electoral disputes. And it shouldn't be the case quite naturally, because if everybody can come to terms that elections are free, fair, and credible, conducted in an atmosphere of equity, you shouldn't have any reason to dispute election results. The fact that there's so much of this we are having, it's a big blow on the commission itself. And the antecedent is that, or the prospect rather, is that if we have to continue in this line with this same set of individuals, using these same parameters in the next coming elections, it will even get more worrisome.
Is it fair to put this blame at the doorstep of INEC squarely? How about the political actors here? Because increasingly, we are seeing the courts play the role of who even becomes the candidate, and that's as a result of lack of internet democracy in the political parties. Then we see the courts also determining who wins the election. So is that not a failure of the political class? Should we blame INEC squarely?
Well, you agree with me that in none of these cases, there is no case that has necessitated the court to shop for electoral matters before it so that it cannot rule on it. It is born out of dispute by parties. But again, the commission that is set up by law to conduct elections is INEC.
But this was the same commission. Because when you put this indictment, this was the same commission. I conducted an election in 2015, and the presidential election never went to the Supreme Court for final decider. The candidate accepted defeat, and he made a call, the first time in Nigeria's history, that we're going to have that. This was the same INEC. I mean, what did they do there that was different from
Quite frankly, we had a progressive leap in the 2015 general elections. The reverse is what we have in this case. In these just concluded elections, we have vote buying, and the European Union made statistics of it, that tripled even the 2015 elections. We had vote buyings, we had killings even of citizens, snatching of ballot boxes and all of those things. So there's a difference from the performance of INEC in 2015 and the one we had in 2019.
But you will not put that at the doorstep of leadership, but you put that at the doorstep of the institution. I want to also ask you a question, because, I mean, correct me if I'm wrong, but laymen will set this precedence, and they'll say this. So if we can say P54 brought a result forward that the Supreme Court accepted, what it means invariably is that if me and you are in a contest for local government chairmanship in our local government, I can get the police to authenticate a result and bring it to you, and I know that you as the court will accept it, because that's what a lot of people were going out to say. What it means to bring from the Supreme Court judgment is that you can swear an affidavit and it will replace your certificate. Correct me if I'm wrong.
Well, in all of the two instances you have said, that exactly is not the case. I can assure you.
That's why I say correct me if I'm wrong.
Nigerians can like to take things overboard a little bit, but that's not the case entirely. Because we still do not know the reasons why the court found favor in the argument of the petitioner to say, yes, P54 is a worthy and credible witness. We will rely on his evidence because we do not know the reasons yet. And we want to say it is not correct in law to say that falsification of electoral results can arise and to be validated by police officers and then to become a standing principle of law. That's not true.
Okay, Real quickly before we go, now the Imo Diaspora Coalition for Justice and Democracy has actually petitioned President Trump to put a ban on travel for the 7-man panel. Very quickly, please, the legality of this.
Well, it is more political than legal because the laws that guide their terrain isn't the same as the one that guides it. And even here, there's no legal structure for such, you know. But it goes without saying that people are aggrieved about the election results.
Definitely.
And we can do much more better.
Thank you so much, Mr. Akinyode, for coming on the show this morning. Well, the PDP is certain. It says it will continue to protest until the Supreme Court revisits that judgment. And that brings us to the end of the show today. Thank you so much for watching. I am Adesoa Omoran.
Rafal City.
And I'm Shaitan Atigari. Thank you for watching. You can also follow us on all the social media handles showing now on the screen. This is Arise News.